So good afternoon, everyone. We appreciate you joining our session here today. And on behalf of the New York Mortgage Bankers Association and our president, Jeff Pinard, our entire board and our education committee co-chairs, both Elizabeth Cheney and Bill Kennedy, we thank you for joining today's webinar with our great partners at Mitchell Sandler. We do have a couple of housekeeping items that we'd like to share before we start. And we also want you to know if at any time during this presentation, if there are any technical difficulties, please use the chat box and type in a message there to notify us, and then we will try to make any corrections as soon as possible. Also, during today's webinar, we make sure that all of the lines, with the exception of our presenters, will be muted throughout the presentation. There certainly will be opportunity to ask questions at the end of the session. But again, we also would like you to use the chat box function that you can just tap into and write in any messages that you have there or questions. And we will make sure that we do our best at the conclusion of the session. Both Ari and Shelby will answer those questions for us and provide that information to you. We also urge you as attendees to take a look at and become a professional with us, along with the National Association of Mortgage Bankers with their Mortgage Action Alliance program that they have. Everybody references it MAA, M-A-A. It's easy, it's free, and it's certainly a nice way to stay informed on all of the different legislative issues that can impact the way that you do business, both today and certainly in the future. So with that, I'm now happy to turn it over to Bill Kennedy. Bill will introduce our esteemed speakers for today's webinar. Bill, please.
Thank you, Joe, and hello, everyone, and thank you for joining. We are going to take a deep dive into privacy with Ari Karen and Shelby Schwartz, and they work for Mitchell Sandler, LLC, which is a woman-managed, majority woman-owned boutique financial services and financial technology-focused law firm based in Washington, D.C. Ari Karen leads the litigation, labor, and employment group, and he represents business and financial institutions in litigation matters, government investigations, and advises clients on regulatory matters. The majority of his clients are in the mortgage lending space, so he knows our world. Shelby Schwartz is a counsel at Mitchell Sandler. Her practice focuses on regulatory and compliance matters with a concentration on deposit account and financial data privacy. Shelby advises a wide variety of financial services providers, from banks to financial technology companies. So they are accomplished, and I'm glad they're here today. And I'm turning the session over to you, Ari and Shelby. Thank you.
Thank you so much, Bill. Thanks for having us here. This is kind of a brief overview of the agenda that we'll be going through today. We call this a deep dive into privacy because we're going to touch a lot of different privacy-specific topics that should be relevant to your business, and kind of give you a more in-the-weeds picture of them than we might be able to cover when privacy is kind of just one of the topics that we are talking about. So I am a certified information privacy professional with the International Association of Privacy Professionals, in addition to being an attorney. And as Bill said, I represent a wide variety of financial services clients. I work a lot with our bank regulatory practice and our fintech practice, but I also work with our mortgage practice a lot, and even sometimes get to team up with Ari when the privacy issues come up in litigation. So I have a pretty interesting view of privacy areas kind of across the industry. We're going to start off by talking about some marketing related regulations and privacy impacts there. We're going to talk a bit about data breach responses, state privacy law updates, and then we're going to finish up on the regulatory guidance on AI and the privacy impacts that are there. Ari, do you have anything that you want to add about the overall agenda?
No, I'll be jumping in, obviously, as you know, talking about it from a litigation perspective and some of the things that we see a lot of times and how they, quote unquote, go wrong when sort of the advice that you're going to be providing today isn't necessarily followed. So that's going to be kind of my role in the presentation today.
Yes, perfect. Yes, I hopefully am the one that you talk to before there's any problems, and then once something pops up, Ari becomes your best friend. So if we can advance the slide. The first topic we're going to be talking about a bit is privacy considerations when we are going to be engaging in any kind of email marketing. And you can advance again. So the primary law that applies to email marketing is CAN-SPAM. It's a long-standing law. The FTC is generally the primary agency that's going to enforce that. And it kind of sets forth a variety of structures and requirements for commercial email. So that's any kind of marketing, advertising, or promotional emails. And it actually extends beyond just email itself, right? So this law is also going to apply to some forms of social media messaging or text messaging. All of those types of commercial electronic messages are going to need to follow the requirements in CAN-SPAM. The requirements are hopefully not particularly onerous or controversial, though. You need to have an unsubscribe or an opt-out feature, and you need to honor those requests promptly, right? So if someone no longer wants to receive your messages, they need to have a way to stop receiving them. And that is very commonplace these days, right? There can't be deceptive routing information. So that means the to line, the from line, the subject line, even the date, frankly, all of that header information, that needs to reflect who the message is really coming from and what the message is really about. As I'm sure you know, when you get spam in your own email inboxes, sometimes people change how it displays, the domain things come from. That's going to be a violation of CAN-SPAM. It needs to be transparent who is actually sending the message. But more relevant is probably the subject line. That subject line really does need to very clearly disclose what the content of an email is, so that if a consumer receives that email, they don't click into it if it's not actually a topic that's of interest to them. So if they're trying to avoid opening up your marketing emails and you are sending something with a subject line that says, you know, you've won a prize or problem with your account or problem with your application, that's going to be considered deceptive, right? Because you're encouraging them to click through based on something that the email is not really about. And the last does, for commercial electronic messages, require a physical address to be disclosed in the body of the email. So that's kind of the overview of CAN-SPAM. It's overall considered fairly easy to comply with. And if we advance the slide, we can see kind of some of the more particular things. So one of the things that people don't like to comply with is unsolicited emails must state #ad in the subject line. Now, we don't see that a lot, and there's two reasons. First, if you have a business relationship with the consumer from which you obtain the email, that is going to be considered a solicited email message, right? So if someone signs up with you, if they give you their email address in any way, they have solicited your communications with them, and that's not going to be required anymore. The other reason that we don't see it is there's a lot of non-compliance with it in kind of like the spam community, and we're trying to stay away from that. If we're truly getting email addresses from people who have no idea who we are, who don't necessarily want to be affiliated with us, and who haven't given their consent to be emailed by you, we're going to want to include that #ad in the subject line to stay in compliance with the law. Now, I know a lot of that kind of ties into monitoring what others are doing on your behalf, right? Because a lot of email marketing is going to be coming through a lead generator. So you don't have to specifically have that business relationship with the consumer, so long as the lead generator got the appropriate consent for you or, you know, other business partners of the lead generator to email. So you are going to be liable for emails sent on your behalf, whether that came from a lead generator, whether you got that email address, and whether you send them or a vendor is going to send them on your behalf. So we do want to be very clear about obtaining those consents. You're going to want to make sure that if you're getting email leads from someone else, that they are getting the appropriate consent for you or a vendor on your behalf to email them. Otherwise, again, you're going to need to put that #ad in the subject line. I think that this is one thing that I want to highlight about CAN-SPAM in terms of privacy, which is very different from the next subject we'll cover, which is TCPA, so phone marketing. You do not need to get prior consent to email someone for marketing. But the difference is that #ad, right? So we love to see prior consent. We generally want to get permission to email so that we don't have to comply with that disclosure. But there is nothing actually to stop you from unsolicited emails. The caveat to that is if you do engage in an email, whether solicited or unsolicited, and someone attempts to unsubscribe, whether that's replying and saying, please remove me from your list, or clicking an unsubscribe button, it is really, really important to respond to that promptly and to take them off your distribution list. And I'm sure every single person on this call can relate to getting emails, trying to unsubscribe, and frustratingly continuing to get repeated, often daily emails from that company. Nobody likes it, and it's certainly not a great way to engender friendly feelings or a desire to do business. And so we do want to be conscious that that is not just a good business practice, but also a legal requirement. Can we advance the slide? So that's what we're talking about, right? This unsubscribe button that I've circled. This is an email that I took a screen grab of it from my own email. And you can see, it makes it very clear who sent me this email. It makes it clear what their physical address is. And there's that unsubscribe link in addition to a manage email subscriptions link. The unsubscribe link needs to be what is more or less a one-click unsubscribe. They have to have the ability to click that button and then click solely one more button if they like to be able to be permanently removed from your list. So the question is, how much is that unsubscribe link really worth? What happens if you forget about it? And can you advance the slide? So right now we're saying that unsubscribe link is worth at least $650,000, right? Last year, the FTC took an enforcement action against Experian for failing to have that unsubscribe link in some of its emails. And there was a $650,000 penalty associated with that. So again, nobody generally wants to do business with people who don't respect their decision to be off the email marketing list anyway. So it is really prudent to pay attention to this because it's a little thing that you can do that has a big impact. Next slide. So this is kind of my last big thing about can spam, and this is a little bit about what I was talking about subject line. So when we look at this subject line, we can say, like, what is wrong with this, right? What's the problem with these emails? These look like emails that Publishers Clearinghouse is sending people. Doesn't look like spam, doesn't look like a problem. But if we go to the next slide, what we find out is that these emails were considered to be deceptive under can spam. They were from Publishers Clearinghouse. The from line was absolutely non-deceptive, but the subject headings referred to essentially fictitious documents that had names that resembled tax documents or other government documents, when in reality, when you opened up the email, it was a solicitation. And again, that's exactly what I was saying before. The subject line somewhat compelled consumers to open these emails. And that doesn't seem like a great deal of harm. You opened an email you didn't want to open and got a solicitation that you didn't really want to see. But it's that deceptive nature that the FTC really takes issue with, right? So there was a significant investigation. There was an $18.5 million of consumer redress required simply for the burden to all of the consumers of clicking emails that they didn't want to have clicked. That essentially the FTC found that they were tricked into clicking. So again, we just want to be clear that the subject line really is describing the contents of the email. Okay, we can advance the slide. The next section that we're going to cover is text marketing. And the regulation, the statute that governs that is the TCPA. We can advance.
And one thing I would jump in, this is an area of definitely to pay attention to where there's a lot of litigation. I mean, candidly, we don't see a lot of litigation in can spam. That's more of a government regulatory / enforcement concern area. TCPA litigation is pretty big. So we see a lot of this, and they're tough cases. I mean, there's a lot of defenses to them in terms of forming a class. But they're tough cases because when they're violations, the violations are pretty clear. So you really want to pay attention to this from a litigation perspective.
Yeah, thanks, sorry for that. And also, I should say that there is more enforcement focus on TCPA from a government perspective than there is in CAN spam as well. So this is definitely a much higher stakes topic. Also, emails, pretty mass, but you can also send quite a lot of text messages or make quite a lot of calls. And there tends to be more attention because people consider these to be more invasive, right? So
And the other thing is, remember, you have people litigate over this. I mean, there are people who literally, I have plaintiffs who have filed 30 of these cases, right? And the point that Shelby made, let's say it's $500 a violation, right? Well, you'd think $500. Well, if you send 1,000 text messages a day and you do it for 10 days, the numbers start adding up very, very quickly to massive amounts of money. Think of a 30-day or text campaign or phone call campaign, 2 weeks of it. I mean, that's thousands of calls at $500 a call. It just could be a lot of money.
yeah, absolutely right. So TCPA applies to anyone making marketing or sales calls, not just within financial services broadly, or anyone sending text messages for marketing or promotional purposes. And there are kind of 4 buckets, I would say, of requirements. You need to have prior express consent to make a marketing or sales call or send a text message. It restricts the use of automated telephone dialing systems or artificial or pre-recorded messages. It limits the number of phone calls and text messages you can make to one individual in a day. And it requires you to create opt-out procedures if people no longer want to receive solicitations from you. And as Ari said, one of the key differences here between this and CAN spam is a private right of action. CAN spam, no matter how aggrieved we are about getting unwanted email messages, there is no right for individuals to sue. But in TCPA, there is a private right of action and you are allowed to form a class. So let's talk a little bit about these requirements. And if we advance the slide, we can talk about what is prior express consent. So when we are going to do a calling campaign, assuming we are not having someone individually dial a telephone for each call, you're generally going to need a TCPA consent. And that needs to be a written consent to contact you, or for a third party acting on your behalf to contact the consumer. And what we want to do is we want to make it pretty explicit. There's a lot of moving parts in this consent. We see a lot of people who attempt to get valid TCPA consent. They put something in a different contract. They put something in an application, a web platform, terms of service, whatever it is, and they think that they're getting TCPA consent, but they're not getting a valid consent. There's a lot of traps in here. So we're going to go through kind of 6 specific things in here that we're going to need to, that you're going to want to make sure that any text or any TCPA consent has. So if you can advance the slide, we're going to kind of highlight them one by one. So the first thing we need is a clearly disclosed method of providing the consent, right? So we're going to either say by checking this box, by clicking accept below. We're going to have to call out very explicitly what the action is that is going to constitute consent by typing your initials, by submitting this application, right? Although we'll get to that last one in a moment. That's the first. So can you, next slide. The next thing we want to do is we want to say who the consent is being given to, right? So you want to expressly consent to a specific company and its affiliates and its business partners, any third-party service providers. You can use categories, right? Third parties acting on my behalf, ABC Mortgage and affiliates, right? But you do want to kind of encapsulate the world of who this consent is valid for. Because if you just say ABC Mortgage and then you're using a third party to make calls for you, that consent is not going to extend to them, and that is going to be a subject for litigation. Next slide. So the other part is you need to have the consent very explicitly use the words marketing or promotional when with respect to the calls or messages, right? It is not enough to say that you expressly consent to getting calls or text messages. That is only going to work for what a regulator is going to see as a quote transactional call or message, right? I need you to fill out this paperwork, or I wanted to give you an update on the status of your loan application. It's not going to be for anything marketing based. And so unless you actually use that word. So that's a lot of times people don't want to put that in because it tends to make people shy away from consenting, but it is not a valid consent for marketing unless it uses the word. Next slide. The other thing that is important is if you are going to be marketing through text messages, if you are going to be using any kind of automated dialing mechanism, if you are going to be using any kind of pre-recorded messages or artificial voice message as part of your calling campaign, your consent needs to actually explicitly call those out. So if this simply said text messages, then it would not cover calls made through an automated dialing mechanism. The consent wouldn't include that, and any calls made using an automated dialing mechanism could result in liability. So you're going to want to either list everything or make sure that you are including in your consent everything that is going to be part of your marketing campaign. Next slide.
One thing also to remember in this area with litigation is if your system that you're using can be an automated dialing mechanism, even if you're not using it for that, right? Because there's a lot of systems that have auto dialing features that you may or may not use. But it's a gray area at this moment. If in fact it is an auto dialing system, even if you don't use it for that, you can still trigger potential liability. So it's important that you understand what an auto dialing system is. There's a very specific definition. I won't sort of go down that road right now, but just understand that if it is, you've got to understand what features it is and whether it meets that definition. Because whether you use it that way or not, if it is being utilized, you can have liability, even if it's not being utilized to auto dial.
Yeah. And I would say in general, kind of our, proactive advice is to try to disclose all of those things. If you think there's any chance that you have the capacity to use them or that you might use them in the future, right? Because you can get a consent to do something and never actually do it, and there's no harm. Whereas, as Ari pointed out, if you don't have that consent, you could find yourself down a bad road.
And let's be honest, when somebody sees this and is clicking it, very, very few people are going to be like, oh, I was going to consent, but I saw that it mentioned an auto dialer because I don't want that. I'm not going to consent. I mean, it doesn't happen, right? You either click it or you don't click it. No one's reading it. Put it in there. It's a safer way to go. There was one thing I don't want to get you off track, Shelby, that I wanted to
Go ahead.
I wanted you to address. At the very first thing you talked about ABC Mortgage Company and its affiliates. One thing that I think a lot of people in the industry see is they will purchase leads that have already been obtained through some type of text message. So in other words, text messages go out from a lead provider and people say, yes, I'd like to find out about a mortgage. And then they sell that information to a mortgage company and the mortgage company then calls. What consent has to be on that from that lead provider to allow that mortgage company to call? Because I think that's an area where a lot of people get in trouble.
I think that is that's certainly, I think that maybe some of our next slides address that as well, Ari, but I think that is certainly one of the most critical areas, right? Where making sure that any source of phone numbers, any source of leads that you have, or anyone working on your behalf, that they really are getting a consent that applies to you too, that lets you have the right to contact them the same way the person who initially got the information would have had.
Yeah, and because a reason I asked that is that's a place where we see a lot of litigation too, where somebody makes calls, they spent the money on the leads, and they find out it wasn't done right. So
Yeah.
being on the lookout for that is important when you acquire.
Yes. Right. So that's definitely a really important point in vendor due diligence, that if you are going to be looking to, onboard a new lead generator, that you are looking to understand what is the exact language of the consent that they are getting, and do you think that it is explicit enough that you would be allowed to contact people through the same means.
Yes, and if it's not, and they don't have that compliance buttoned up correctly, I promise you, that's just the beginning of a whole bunch of problems that we see with the vendors that do some of this stuff.
I think that's right. So this one that's up on the screen now is fairly straightforward. The consent needs to say what the messages are about. It can be pretty generic. It could say related to financial products and services. It could say mortgage related products and services. It can't just say products and services. We don't need to be a lot more specific than financial products and services or mortgage related products and services, but we do want to give people some idea about what they're going to get calls or text messages about. Next slide. And this is the most important one, or at least certainly one that we see, I see a lot, where people get their consents to not be valid, right? Unintentionally. You need to have a statement that the consumer understands that the consent is not required to obtain any products or services, and that needs to be true, right? So this has to have optionality. If this is part of an application, or this is part of wherever you're putting this, right? They need to understand that they can go ahead and get whatever product or service they wanted without ever agreeing to get a text message, without ever agreeing to get a marketing call. And you need to have a mechanism by which you are actually recording who you have consent from and who is on that do not call, do not text list, based on who did or did not actually accept this. So before I mentioned, maybe this goes on a loan application, right? And you're getting consent to contact them for other products and services. But if it's in the loan application, it cannot simply be by submitting this loan application, I consent, because there would be no way for them to then get the loan without consenting to the text messages, or without consenting to the automated dialed calls, or whatever it is. So we do need to make sure that whenever we're considering this type of marketing, that the consent is truly optional for the consumers, and they can obtain whatever it is, the product or service that they're interested in, whether that's actually the financial product or service that they're looking for, or whether that's a download with 10 tips for whatever, that they can get that without providing the consent that is required to be optional. Next slide. So there has, as Ari and I pointed out earlier, there has been a lot more action, both in the government enforcement action side and in class actions in TCPA than in CAN spam. So you can see last year there was an enforcement action against Life Management Services. They were said to have bombarded consumers with illegal robocalls in attempts to sell them bogus credit card interest rate reduction services, right? And they didn't have the consent to use automated dialers. And they also exceeded the number of call attempts per day that were allowed. And that was a joint action between the FTC and the Florida Attorney General. We also in 22 saw First American Payment Systems. They violated the Do Not Call registry. It ended up in $4.5 million of consumer redress. So these things, as Ari pointed out, it feels like a small violation, but it adds up extremely quickly when we consider the volume of text messages or the volume of call attempts that we can make. And it is per call attempt. It is not per completed call, right? So
yeah, and just so we're clear, an attempt does mean the phone rings.
yeah.
Okay, so if they call 6 times your house or whoever's house, right? If you call 6 times, the phone rings 6 times, nobody picks up. That's 6 times 500. That's $3,000. Okay. Now, if they did that, you get it. I don't need to do doing the exponential math, but you understand how quickly that adds up when you're talking about these things that are done through these services. You're talking about hundreds of millions of dollars, like that Capital One settlement. And I'll tell you why a lot of these cases settle. There are a lot of defenses to class certification because, I mean, it depends on how many vendors are used, who's making the calls, how the calls are made. But there's a lot of times where you can have a lot of defenses if you know how to litigate these cases. But the sheer volume and number you're talking about, like, I don't know the Capital One case, but if they settled for 75.5, I guarantee you the size of the class was hundreds, I mean, several hundreds of millions, right? Like that was probably the size of the class they sought, maybe even larger, right? So it just gives you a sense when you see these settlements. These aren't like, oh, they asked for 20 million and they got 15.7. Based on the class size, it was probably $500 million.
And the other thing when we talk about the volume of calls or consumers, it is not simply people who are annoyed, right? It is not simply people who say, oh, I didn't want them to call me, right? Those calls, if they got picked up, they could be very welcome, right? They could result in them obtaining the product or service.
Yeah,
That does not negate the violation, right? They still get $500 because you weren't supposed to call them in the first place.
I mean, I'm actually making that argument right now in a case because we have a class full of people who actually obtained mortgages through the defendant, and we're making the argument: how could you not consented? It's a little more complex than that, but I mean, the point being that we have a large number of people who actually got mortgages from us who are suing us for these violations because they're saying that, yeah. So I mean, I have cases where that's an actual issue. We'll see how it develops. It's kind of a cutting edge argument. But to the point that Chubb is making, it certainly doesn't guarantee you any level of protection.
Certainly not from the government, I would say. And
Well, yeah, this isn't a private action.
Test out if it works as a private right.
Yeah, we'll see. We'll see if that happens. But yeah.
Ari, Bill's asking if we can give an example where the violation was specific to buying and marketing mortgage leads. Do you have one off the top of your mind for that, or?
Yeah, I have to, protect names and faces but yeah, no, I've many. I mean, we litigate a lot of these, but I have one where I had this is probably where I had one loan officer go off on their own by actually what they did is they took, I'm just trying to be careful so I don't divulge anything. They took some realtor friend said, oh, call all my, so some realtor had a list. Realtor friend said, oh, you should text all of my clients that, your mortgage services. List was sent. He sends it out using some type of auto dialer service that the loan officer gets on his own, right? Because the company really didn't know what he was doing, and sends off, like 3,000 texts. We get sued. Now that's what, if I'm doing my math right, about $150,000, right? I think I'm doing my math right on that.
That's right.
So now, is that one of these $15.7 million cases? No. But imagine being the president of the company, you get a lawsuit for $157,000 because you're low. And I mean,
just one guy.
Yeah, and I mean, there's no question you would have the arguments of, without getting into each of the legalities, but they're an agent, they were acting in the scope of their employment. There's no question there'd be potential liability. Yeah, you could fire the loan officer later, but what are you going to do about it now? Because you've got a lawsuit on your hands about this. And, under the merits of the case, I mean, we ultimately settled the case, right? But I mean, there's issues there, right? And here's what gets particularly bad. It's not like the plaintiff's lawyer in that case said, oh, it was only 3,000 because of this loan officer. Say, I believe you. They want to see how many other loan officers said stuff and how many other. And so you end up in this wide-ranging discovery, which is why the case ultimately settled, was because it isn't like they come in and say, oh, I believe you was only. They say, I want to see every other loan officer. I want to see every other text that was sent. I want to see. It's just the beginning of a much larger thing. That's why a lot of these cases settle, because the discovery is brutal on them. Now, again, if you could beat class certification, that's one thing, and that's where we're going. But at least we're able to get a reasonable settlement of the case. But that's kind of the reality of what happens in a mortgage context, or really in any context. But it certainly happens in mortgage.
Yeah, and I would say, Ari, when we talk about kind of that wide range discovery, it's going to be probably the same thing that's going to happen in a government enforcement action, right? They might be starting with, okay, these 3,000 people didn't give consent, but now I'm getting wider ranging discovery, and now I see these one-off errors in your opt-outs, right? In your unsubscribe, in your, stop messages, in your do not call list, and those are also getting added in, right? We're finding more and more TCPA violations that we can make these kind of subclasses for as well.
Exactly, because like, yeah, in that case, they wanted to see, well, if you don't have any policy, you don't have any protection, how do I know, any of the other 100 loan officers aren't doing the same thing?
Right.
That's where you start getting into, legal, some serious legal costs to fight all that stuff.
Okay. I think we can go on. Ari, this is I think some more of what we were talking about, right? That when it comes to litigation, consent is not assumed, right? You have an affirmative duty to prove consent in litigation.
Yeah, and that's the big thing when you're doing your vendors. I mean, this is where it's so frustrating. A lot of these companies that you really got to vet your people or not people, but the companies you work with. I have so many cases where the vendor's gone out of business. The vendor doesn't keep the records. The vendor didn't have consent. Now, this is great. I know everyone's like, oh, we'll sue the vendor. For what? If they don't have any money, it doesn't, I mean, it may feel good, but it doesn't really help you, right? And think about it, the plaintiffs aren't coming after the vendor that's third of your or 10th of your size, right? They're coming after you. You deal with it. So you've really got to prove this. And there's, I've even seen scenarios where we're given documentation by vendors that show we had consent, and then the plaintiffs in God have demonstrated those records were false. And I mean, even in a case where I called the general counsel for that company, it was a smaller company, and said, this is what they're alleging. And they, said, well, we probably shouldn't get too far into this, meaning that it was. So we didn't obviously know it, but here we are dealing with it. So you've really got to be careful when you buy these and you vet these vendors that they're legit and doing it the right way. Because if they're, a lot of times they'll tell you they are, and they may not even realize it themselves that they're not.
And I think that I'm going to just add on and say, like, this is a pretty general theme when we come to privacy in the financial sector, that for all of this marketing, for all of the personal information we take, a ton of this relies on vendors, right? That's just the way business operates. You're not doing everything in-house. That would be extremely unrealistic. But at the end of the day, the buck stops with you, because the assumption is that it is your responsibility to thoroughly vet the vendors, and that you are going to be liable for their actions, right? We often say, you can outsource the task, but you can't outsource the liability. And that's going to be true. And it really is critical to have business partners that you work with, and to make sure that your contracts with them give you protections, to make sure that they give you rights to audit, to make sure that you are using those audit rights to find these things before the government or a very greedy plaintiff's attorney finds them for you. And to stop doing business with anyone that you think is not doing things above board. That's the other thing. We want to make sure contracts give you the right to terminate those relationships if you are finding evidence of TCPA noncompliance. You want to be able to exit very, very promptly. Next slide. So Ari, do you want to talk about some of these are litigation defenses? So
yeah, so I mean, first thing, you want to ask about, we talked about consent already. I mean, you've got to be able to establish and go through when you vet these vendors that there was consent. That often becomes an area where we can establish, or where you could decertify a class, because if the consent was obtained different ways from different people, and there's different questions of fact around that, that's a definite defense area where you can prevent a class from getting certified in the first place, which is really the strategy here in these cases. Once the class gets certified, it's much more difficult. If you can prevent the class from being certified, and there's a lot of ways to do it, then you can make a lot of these cases go away. That's why a lot of times when we've had a lot of success on them and settled the cases, we've either decertified the case or made it very clear to the plaintiff we're going to be able to either decertify or make it very small. Then the next thing is, in some cases, look, and this depends on your facts. Some cases, there's a mix of texts going out to different people for different things. Some of which might be solicitation, some of which are not. If it was a solicitation, that's obviously not going to be defense, but I've had cases where it's all kind of mixed in. And then the question is, well, what was that call for? Right. So when a plaintiff tends to try to get overbroad and say every single phone call, every single text message was a problem, that can be a defense too, because you have to be able to show that it was for the purpose of purchasing, renting, investing in good services, so forth and so on. The biggest one though is that ascertainability. The do not call us when you get a DNC case, for example, and that's a lot of these cases are DNC. They just give what you'll find out though is that you have to identify that phone number obviously to a person. First of all, that requires there's issues with the DNC, whether the DNC was updated, whether they have the records, because a lot of times they don't, and they need to have the actual records. Because if they just have, a smattering of records, or they don't even have the DNC records, or they use an old record, because that DNC, those change from time to time, and also the identity has to be of a number, has to be identified with a person, and that can change too, particularly on home phones, not as much as cell phones. Those records have to be up to date. The other thing is that, when you get this phone number, then you have to go to the phone carrier. Well, do you know who the phone carrier is? Because if you don't, that's an issue. What are you going to subpoena 500 phone carriers? So that's an issue. So, okay, let's say if they get past that, well, how do you know those records are up to date? And how do you know all those cell phone carriers from 5 years ago, if that's what they're suing, right, have those records still that would identify that person to that phone number? And then you get to the point of what if you have like group and family plans? So like, in other words, in my house, I'm the only, if you ask, there's probably 7 phone numbers in my house, right? The only person who gets a bill and the only person they know of is me. They don't necessarily have a phone bill that would have those other 6 people. And remember, those other 6 people are the plaintiffs. So you have to be able to identify those 6 people. And this is not just a strange thing. I mean, if you actually, there's some statistic I recently cited that I think it's 65% of people are in group family plans, or 75. It's much higher than you think. And so these are all issues that, because you have to be able to ascertain your class members with a great deal of specificity and reliability, and you can't just throw it out there to the world, if you can't establish that you're going to be able to ascertain, or they can, who these class members are, you can decertify classes. These are areas and things you need to be looking at if you get some of these cases.
Okay, we can move on. I think we talked about all of this, so let's keep going so we can hit some of the other topics. I'm going to talk pretty briefly, I think, about third-party marketing, so that we can make sure that there is still some time to cover our last 3 topics, if you can advance. Third-party marketing is generally covered by the Gramm-Leach-Bliley Act that restricts your ability to share consumer personal information with non-affiliated third parties. So that's going to be their name, social security number, financial account number, telephone number, really anything that lets us identify that. GLBA is really broad. It has a lot of data security, information security obligations, and it also has these restrictions of sharing information. So this is we're going to talk a little bit about one aspect of GLBA, but it is very large and important. And you can continue. One of the first things I want to point out is there is an exception to the restrictions on sharing confidential information for joint marketing agreements, right? So 2 financial institutions, 2 companies that are covered by the GLBA, they can have a written agreement, right? Or one company that's covered by GLBA can make a written agreement with someone else, where that someone else is going to jointly market with them. And as long as that they're all committed to protecting the personal information in the same way, there can be sharing of that information. The thing that we need to be really careful about in the mortgage space is RESPA, right? So there are kickback considerations that can arise when we're talking about doing joint marketing agreements related to mortgage origination. So not all types of joint marketing agreements are going to be permissible. If you're considering a joint marketing agreement, you need to work with counsel very closely to make sure that you're not going to have any RESPA considerations. In general, you can't pay for click-throughs. You can do some kind of co-endorsed products, but it requires really careful analysis. Our firm advised a credit union and a homeowners insurance company last year who wanted to do some joint marketing agreements. And we ended up with their particular scenarios, kind of advising them that there could be a joint marketing agreement related to servicing issues, right? But not necessarily origination clients. And so it gets pretty detailed. It is an avenue to work with if you do want to work with another company to do joint marketing. But again, because of RESPA, we are going to want to be extremely, extremely careful. We can advance. So the other way that we can share consumer personal information for marketing or get consumer information from others is through what is called non-affiliate marketing. And that means that you're going to need to provide a GLBVA privacy notice and a reasonable means to opt out, which means people get to say, don't share my information, and that you need to respect that decision that they don't want their information shared. There's a variety of reasonable methods of opting out, right? There could be checkboxes in a prominent position on a form or in a web form. There can be a mail-in form. There can be an email address. There can be a website they have to go to. There can be a phone number. That part is pretty operationally flexible as long as it's fairly accessible to a wide swath of your consumers, depending on how you're actually doing business with those folks. But the key that I want to point out is that you have to wait 30 days after providing that privacy notice to begin sharing personal information with anyone who's non-affiliated, right? And that is, you need to give them those 30 days so that they have that chance to actually act on their opt-out right. So we've had this come up a lot of times where people want to enter into an agreement where they pass along a new customer's information for joint marketing. But you can't do that. You have to wait. You have to let that 30 days pass, because the idea is maybe on day 29, they want to tell you, don't pass along my information. So there is that kind of cure period, that waiting period that we want to be really cognizant about with third-party marketing. Next slide. So data breach responses. Next slide. So the most important thing that when we talk about data breach responses, when we've mishandled or lost track of some people's personal information, is that this is not an if, this is a when. In the modern world, we will all have a data breach. And we need to be prepared for the response, right? So what is a data breach? Well, there are a lot of different regulatory definitions that apply that kind of define what a data breach is. And you're going to want to be really cognizant if you do have any type of suspected unauthorized access or suspected leak of information, that you are looking at all the different definitions that might apply to the consumer population that you're dealing with. So there's one definition in the GLBA. If there are any federal mortgage loans that you have, both that are both agency specific and sometimes loan specific, they might have their own definitions of what constitutes a data breach. There are each state has its own definition of what constitutes a data breach, and those definitions talk about whether it was malicious or negligent, what PII was implicated. In general, Social Security numbers are always going to result in a finding that there was a data breach, similarly for driver's licenses or government ID numbers. But then there's a lot of variations about whether financial account numbers on their own, if they are out there, constitute a data breach, usernames and passwords, addresses, phone numbers, whether things can be found in a public record, are going to change whether or not we are considering that to be a data breach. The other key data point is that we're going to consider is the number of consumers impacted. So while we might have a non-regulatory specific data breach, right? So we accidentally emailed someone a loan file for a consumer, that it was just, we auto-filled the wrong name in and now it's gone to the wrong person. Generally, a single consumer is impacted is not necessarily going to be enough to qualify as a regulatory data breach. Next slide.
One thing I also want to just say real quick is that, you know, you've got to comply, you've got to follow these rules. And the reason I say it is I know that there are people out there say, oh, well, we'll just report everything it's data breach, which you don't want to do, because then, you know, the states, they report this information. And then sometimes plaintiffs' lawyers get it. And so if you just took a position of, oh, well, I wanted to be safe, so I called it a data breach, do not do that. You're creating other risks for yourself. This is one of those where it isn't like to be safe, you know, safe, be sorry, right? It's get it right. I mean, you gotta, if you have a data breach, you gotta report it, because that's really bad if you don't, right? But don't just say, oh, well, I'm not really sure, so I'm gonna err on the side of. That can create problems too.
Yeah, and like if you go down to this bottom thing, right, where we're talking about what does it mean to report a data breach, right? There's a variety of, depending on which of these regulatory definitions you're tripping, there's a lot of different people that you have to notify maybe. So you might have to directly notify the consumers. And that is often a tip-off under a lot of state laws that have private right of actions to start putting together a class. Right?
Yes. And that's the thing, like but if you start this and you, let's say it wasn't a data breach, you don't know, or what, you're not really sure if that information would make a data breach, and you're not really sure if it was compromised, but you go and you tell all these people, but you don't notify consumers. Well, was it a data breach? It wasn't, because you told the government, but then you didn't tell the consumer. So, right, you get into this really clear Hobson's choice that you don't want to be in. So you've got to do the investigation, make sure you have the right information, and make the right decision based on that.
The other thing that I want to point out is, like, when we talk about data breach response, the very first thing that you want to do when you suspect a data breach is you want to find your incident response plan. And this assumes that you have created an incident response plan, and you absolutely need to have that, because you don't want to be figuring out what you need to do when you need to do it. You want to have taken the time to outline the steps, who in your organization is going to be on this team, who are your points of contact, where you're going to go. You want that to just be following a playbook. And if you're writing that playbook at the same time you're trying to deal with this fire drill, it's going to be a mess. The next is generally, we're looking at containment. We're looking at getting the IT security folks involved, usually. And then after there's some amount of containment and remediation of whatever the breach is, we're going to do a full investigation. Usually, my role in this, in helping someone ascertain whether there has been a data breach or not, comes in during this investigation stage. We don't want to, just like Ari said, we don't want to conclude that there was a data breach before our investigation is done. We want to understand the full scope of what information it was, who it went to, as much as we can tell, and who was impacted before we conclude there was a data breach. And only then do we say that there was a data breach and figure out if it's reportable. The other thing I just want to say is data breaches we normally think of as like malicious data breaches, right? There's an email, a phishing email that went out that someone clicked on and a hacker got access to your database and accessed documents that had social security numbers. That's like a very classic data breach example. But there's also, truthfully, a lot more data breaches probably are inadvertent. They're negligent, right? And like I had about 18 months ago, I had a very old school data breach case come to me, right? A bank improperly labeled and secured their shredding bin. Their janitorial staff thought the shredding bin was regular trash, dumped it in their trash carts and put it in the back of a pickup truck. The trash bag broke open on the way to the dump and scattered customer documents with personal information, right? No one was trying to access that information, but that information did go out through negligence, and that is still a data breach, and it did end up being a reportable event. And so we need to be cognizant. It is both electronic and paper information in most cases, and it is not just, it's accidents too. It is that autofill where you accidentally emailed the wrong person. That can be a data breach. And we want to just keep our guard up about a wide response. And generally we don't see people getting, well, go to the next slide. We do see enforcement actions, but generally we don't see big ones unless people are not taking careful steps to guard against this and to respond properly. But they can be quite large. And the one thing that I want to point out is the reason Drizzly's on here, right? That's an alcohol delivery service, or an online alcohol marketplace. And you're like, what does that have to do with me, as a mortgage banker? The reason that's on here is there was an intense focus, and there is an intense focus at FTC right now about individual liability. And in Drizzly, the CEO was found individually liable and individually had to enter into a consent order. And that is their agency priority right now across the board, but most specifically for data breaches. And so that is another reason just to pay a lot of attention to this area, because they are naming and holding individuals accountable.
Yeah, and I know we're running real short on time. I just want to say one thing about the class actions. We are going to see there's been kind of a sea change in these. Before, these cases were mostly focused on honestly California, because California had personal right of action, I should say, that a lot of other states didn't. But now plaintiffs' attorneys, you probably saw the lawsuit against Lawn Depot. There's one against Rocket, where they're actually now filing these cases on these very new novel theories. Now, whether they will succeed or not, I kind of don't think they will, because I think there's some very good defenses. The point being, though, now they've gotten these really creative lawsuits under like old common law, where they're filing and saying it's negligence, or you breached a contract with me because it was implied that you were going to keep my information safe. And it takes one or two activist judges to give those a lot of credence, and you never know if you've got that judge. So I expect there'll be some settlements in those cases. No one wants to take the risk of the size of those types of cases. But as those happen, the big ones will happen, but then they'll get smaller, right? And then eventually it's going to be dealing with your scenario. So I do know we're running a time, but you definitely want to pay attention to these class actions. There's a lot of defenses to them, but you're going to see them much more widespread, much more frequent. They're going to be hitting all the time.
Kind of a good segue into our next topic, if we can advance, which is state privacy laws, and advance the next slide. 14 states have comprehensive data privacy laws. 18 more states have active legislation. So it used to just be California. As Ari pointed out, things used to be in the privacy world, used to just be California. It is growing. The federal government does not seem particularly inclined to step into this space in a comprehensive way. And so we are going to see it piecemeal across the states. Of the 14 states, 13 states currently exempt financial institutions subject to GLBA, like mortgage companies. But a lot of those 18 states that have active legislation, at least 3 of them that I know of, do not exempt financial institutions. And a lot of those have private rights of action built in as well. And so we are going to be seeing more states with private right of actions for data breaches for not complying with consumer privacy protections. California has a GLBA exemption, but it's data specific, not entity specific, right? So if you're collecting that phone number for text messaging marketing or from a lead generator, that is not going to be subject to GLBA, and it is going to be subject to the state law. And these laws require more extensive privacy notices, more extensive rights for consumers to opt out of things, to request that you delete their information, to turn over data to them. And it is a really consistently evolving place. We see a lot of activity in this, and it is changing constantly. You can go to the next slide. I'm just going to, we are at time, so I'm just going to say quickly, there are state-specific CAN spam laws. Federal law preempts most state-specific laws, but some states do have more specific CAN spam laws than the federal one. There are a lot of state-specific TCPA laws. They vary from the federal law in some respects with the details, what kind of do not call lists do you need to maintain, what calling hours are, how many calls you can make, what records you need to retain. And so again, if you are going to be engaging in telemarketing or text message marketing, you're going to want to make sure that not only are you in compliance with the federal law, but you're going to want to know where the people that you are calling are located, and make sure that your calling hours and call attempts and all of those things are also going to be state compliant. There are other state specific marketing laws, like you can't send direct mail that looks like a sweepstakes in some states. You might need to be licensed or bonded to make calls in certain states. You have to give certain kinds of disclosures with free trials. But those are overall less pressing than kind of the more comprehensive state data privacy changes. Next slide. I'm going to skip over this because children's online privacy is not hugely applicable to you guys. Next slide. And we're going to get into like the briefest of things of regulatory guidance on AI. Next slide. AI is the hot new topic. AI has a huge focus from the federal government right now. And frankly, nobody really knows what to do with it. Everyone's very interested in it, and no one really knows how it works. I think that the important thing to know is that AI is imperfect, right? We are at the 1% mark of the growth that AI is going to show in life. But AI is subject to a lot of limitations. It has a machine learning bias, right? So AI only works on the current data set that you have, right? So if there's a bias in your current data set, if your current data set isn't skewed in a particular direction or not fully representative, you're going to create a greater bias than that, and it's going to completely continue to self-perpetuate and grow. AI also completely hallucinates. It wants to provide answers, so it will make predictive assertions without facts. In the legal arena, there have been a lot of instances of AI, like lawyers using AI and filing briefs, and then like it's literally created. Oh, Ari has to leave. I'm gonna finish up solo. Thank you, Ari.
Bye.
See you, Ari.
AI will just make up cases and say, like, in this case, the Third Circuit said XYZ, and that case literally never happened. And if you're not really checking AI constantly, you're going to do it. So to the extent that you plan to use AI, particularly in marketing or things like this, we do want to just ground it in reality and make sure that we still have human beings having oversight of it. Next slide. The other thing just to know is that, again, if you're going to use AI, particularly in terms of marketing, there's a lot of focus on AI and copyright infringement. This is something the federal government's been really interested in, whether AI is scraping copyrighted data and then reusing it without proper attribution or compensation, so that there are privacy protections for certain kinds of information. And we want to be, again, just very cognizant of that and very skeptical about our use of AI. Next slide. The FTC has made a report to Congress on this. They kind of focus on the things that we've talked about. Next slide. And I think that this is the thing I want to focus on, particularly for us. There's a big interagency statement on AI that came out last year. And the key takeaway that we see from the federal government is a reminder that using AI, using machine learning, using computers or advanced technology does not excuse you from the underlying financial and other regulatory laws that apply, right? So a big focus, for example, is FCRA. You can't tell someone, I don't know why we're denying you. The algorithm told me so, right? That's not enough. Complexity and opaqueness that AI introduces is a risk, and does not excuse any kind of potential violation of the law. So we really still, as humans, need to be in control of AI. We need to understand what it's doing, because the agencies are not going to look at that as a pass. They're not going to say, oh, there was no intent to violate the law. You used AI and the computer did it. You will still be responsible for those violations. Next slide. Also, there's some informal guidance from the CFPB. There's a lot of skepticism about using chatbots that use AI because they tend to be very frustrating for consumers. They're not great enough at understanding what consumers are working to. So to the extent that you're using automated customer service, we really want to make sure that we are still giving people an avenue to get to a human being if they need to. Next slide. And that is everything that we had planned, and I'm happy to take any questions to the extent that I haven't already covered them. I do see that there's one question in the chat. Can I address the case if a loan officer keeps a copy of customer NPI, PII, and takes it with them when they go to a new company? Is that a data breach? Yes, that is historically a problem in the mortgage industry. That is an unauthorized access of consumer personal information. Whether we're going to call it a regulatory data breach, as we talked about, is going to be dependent on all of those factors: whose information, how many people's information, what the information was. If they're just taking name and phone number or name and email, is pretty unlikely to qualify as a data breach. If they're taking loan files that are going to contain like social security numbers and they took 1,000 of them, yes, there is a high likelihood that in many states that's going to be considered a data breach. But we're going to need to consider where those consumers were located, the specific number of them. It's also, as you know, and as a lot of the cases Ari does focus on, in the industry, it's very common to have non-competes and non-solicits and non-disclosures and really strict restrictions against taking that information, even though it is a very, very common practice. And so we do see a lot of litigation that results from when this happens. But there is this flip side, right, where sometimes that litigation can be hindered if someone took a very, very large amount of information that would have triggered reporting requirements. You found out about it and you didn't report it, but now you want to go after them privately for taking it. It makes it very hard to do that because you don't then want to disclose that you had a reportable data breach that you didn't actually report. So that is that's a really good thing to bring up. Yes, people leaving the company, taking information with them, that is a really key time to be thinking about whether a data breach has occurred. Are there any other questions?
Shelby, there does not seem to be any other questions. That was the one I was just going to pipe in, but you got it. So thank you very much. And great job. There's a lot of great information. It's very thought-provoking, kind of scary.
Well, I'm very glad to have been here. I hope I didn't scare you too much, but please do reach out to us if you have any follow-up questions, if there's anything specific that you want to talk about. I'm always happy to talk about privacy all day long. And like I said, most of my work is proactive, right? I'm more focused in most instances on helping you prevent these things. I certainly do work with Ari, and I do data breach analysis and things like that, and handle government investigations in the reactive. We already had a problem sphere, but it's generally I find in this arena, what is it? An ounce of prevention is worth a pound of cure. And so I really do encourage you to take a more proactive look at your privacy kind of ecosystem, because we really can head off a lot of problems with very simple solutions if we're paying attention to it before things happen.
That's excellent. Great piece of advice. And you're right. I mean, a lot of companies, unfortunately, will wait until they have a situation or an issue and then, oh God, what do we do now? Right. As opposed to, taking an advanced look, what do we need to fix? What could we change, and try to address it in advance. So really good advice, Shelby.
Okay. Well, thank you.
Yes.
And thank you for having me. It's been a pleasure.
Yeah, same here. Again, we'll kind of wrap it up here, folks. I know we went a little bit over, but certainly great information. And as Shelby said, please follow up with her directly should you have any additional questions or looking for some more guidance.